So hello class. Today we will be discussing credit transactions. So not all credit transactions obviously, but yung mga required lamang ng course ninyo. So what is required in your course? Yung pledge and also mortgage. So mortgage, dalawang klase. We will be discussing real estate mortgage or real estate mortgage, magkapareho lang yon. And yung second one is yung chattel mortgage. Anyway, we have already discussed a third kind of mortgage, yung equitable mortgage, which we have studied when we talked about yung conventional redemption. So anyway, ano nga ba naman kasi ang mga credit transactions? So ang credit transactions, they refer to contracts or agreements based on credit. So it will include all transactions involving the purchase or loan of goods, services, and also money in the present, which with a promise to pay or deliver in the future. So dahil sa credit transactions, mas marami tayong pwedeng pasukan ng mga exchanges. Mas marami tayong pwedeng pasukan ng mga iba't ibang klaseng transactions. Bakit? Kasi we get money today. We get goods today. We get something in the present, but we have to pay for it in the future. Siyempre, di ba? Ang saya nga naman nun. Gamit na, hindi mo pa bayad. So, yun ang credit transaction. So, they are really contracts of security. So, there are two types actually. Yung mga secured transactions and also yung unsecured transactions. So, secured transactions, they are contracts of real security. Yun ang ibang tawag doon. So, they are supported by a collateral or an encumbrance of property. So, merong collateral at yung collateral na yan ay property. So, yung encumbrance is affected as follows. Remember, para sa pledge, the encumbrance is affected by placing the movable property in the possession of the creditor. So, bigay mo sa creditor yung movable. Now, in chattel mortgage, by execution of the corresponding deed substantially in the form prescribed by law. So, you will execute a chattel mortgage contract. That is how you will effect the encumbrance. What else? In case naman of a real estate mortgage, by the execution of a public instrument encumbering the real property covered thereby, and by registration of the same later on. In case naman of Antichresis, remember, by a written instrument granting to the creditor the right to receive fruits of an immovable property with the obligation to apply fruits to the payment of the interest and thereafter to the principal obligation. So, kasama naman kasi talaga sa chapter na to, sa book ng book 4, yung book on obligations and contracts. Kasama talaga yung chapter na ito. Sa chapter na ito, yung Antichresis. But I'm not sure why hindi siya sinama sa coverage. Anyway, dapat masaya ako, no? That is one less chapter to discuss. So, yun ang secured transactions, which we will study, 3 of them. For unsecured transactions, they are otherwise known as your contracts of personal guarantee. So, here, remember, those the fulfillment of which by the principal debtor is secured or supported only by a promise to pay. So, nangako lang na magbayad or the personal commitment of another person. So, sa unsecured transactions, kaya siya tinawag na contracts of personal security because in addition to the debtor, somebody else will promise to pay, like a guarantor or a surety. So, yun ang unsecured transactions. So, anyway, let's deal with yung pledge and mortgage. So, we are actually talking about title 16 of obligation of the civil code. of the Civil Code. So, we are dealing with Title 16, which talks about pledge, mortgage, and Antichresis. So anyway, ang i-discuss ko today is yung Chapter 1, or the provisions which are common to pledge and mortgage. So anyway, before that, we should study first ano ba ang characteristics ng pledge. Later on in Chapter 3 and Chapter 5, dun yung malalaman yung mga characteristics ng mortgage. So, in a pledge, take note of the definition. Sabi niya, it is a contract by virtue of which the debtor will deliver to the creditor or to a third person a movable property or an instrument, pwede naman daw instrument, evidencing incorporeal rights. Anong purpose? For the purpose of securing the fulfillment of a principal obligation, with the understanding that when the obligation is fulfilled, the thing delivered shall be returned with all the fruits and accessions. So, yun ang contract of pledge. So, nangangako ang debtor na i-deliver ang isang movable property. Anong example ng mga movable property? Vacuum cleaner, washing machine, ano pa ba? Di ko na alam, basta ganon. Basta mga mga movable property. Cellphone siguro pwede yan. So, pwede rin daw instruments evidencing incorporeal rights such as certificates of stock. So, that will evidence yung mga certificates of stock, they are evidence of ownership of shares of stock in a corporation. So, pwede yun na lamang ang i-deliver mo. So, anyway, here, the debtor will deliver these movable things or instrument to the creditor. Or, pwede rin namang i-deliver niya itong mga ito sa isang third person by agreement of the parties. So, bakit niya ginawa yon? Para i-secure yung fulfillment ng principal obligation. Now, question, Ma'am/Sir, ano po ba yung principal obligation na tinutukoy dyan? The principal contract of loan. So, remember, a pledge secures a loan. Ang loan na tinutukoy natin dito is mutuum, ha? So, anyway, with the understanding that when the obligation is fulfilled, kapag nabayaran na daw, yung bagay na binigay or yung instrument na binigay will be returned by the creditor to the debtor with all fruits and also accessions. So, yun ang definition ng isang pledge. Now, the characteristics of a pledge. Number 1, it is a real contract. So, ang real contracts, diniscuss na natin yan. Diniscuss ko na, ilang beses ko nang sinabi to. Perfected by delivery of the thing pledge. So, the debtor will be called the pledgor. So, the pledgor will deliver to the creditor yung thing pledge. The creditor is known also as your pledgee. So, yun ang tandaan natin. Tingnan nyo, debtors-pledgor, creditors-pledgee. So, bakit ganun? Kasi may utang talaga. This is really a contract of a loan. A pledge is really to secure a contract of a loan. And then, yun na nga, mayroong collateral na ibibigay doon sa creditor. Now, also, take note, it is accessory. Why? It is not independent, or meaning it has no independent existence of its own. It cannot stand alone. Remember, a pledge is dependent upon the principal contract of loan. What else? Number 3, it is unilateral, meaning it will create only an obligation on the part of the creditor to return the thing subject thereof upon fulfillment of the obligation. So, sa madaling sabi, obligasyon lamang ito ng creditor na ibalik yung bagay kapag ka nabayaran na yung utang. Yan. So, yung utang ay yung principal obligation, and it will create, pagka nabayaran na yung principal obligation, which is the utang, it will create an obligation on the part only of the creditor to return the thing pledge with fruits and also accessions. What else? Number 4, it is subsidiary, meaning the obligation does not arise until the fulfillment of the principal obligation which is secured. So, yung obligasyon ng creditor na ibalik yung object or yung instrument evidencing incorporeal rights will only arise if the principal obligation is paid. So, dun pa lamang ibabalik kapag nabayaran ang utang. What else? The kinds of pledge. Siyempre, lagi ko namang tinuturo ito, voluntary or conventional. Anong ibig sabihin? Kahit hindi ko pa binabasa, alam ko naman talaga kahit hindi ko basahin, by agreement of the parties. And also legal, syempre, created by operation of law. Diba? Sabi ko sa inyo, lahat ng voluntary, lahat ng conventional by agreement, lahat ng legal by operation of law. So also, take note of the common provisions in pledge and mortgage. Ang una dyan ay ang cost or consideration sa isang pledge or mortgage. Ano nga ba ang cost or consideration sa pledge at saka sa isang mortgage? So, because they are accessory contracts, remember, their consideration is also the consideration as that of the principal obligation. However, class, take note here that if yung nagsangla or nag-pledge is not the debtor, the cost is the compensation stipulated for the pledge or mortgage. Or pwede rin naman yung kabaitan lang talaga ng pledgor or mortgagor. So, it can happen, class, na ang isasangla mo dito ay it can happen na ang debtor wala siyang property or wala siyang isasangla pero merong ibang tao na magpe-pledge or magmo-mortgage ng kanilang sariling property to secure the debt of the debtor. So, it can happen that way. So, ngayon, ano ang cost or consideration para dito sa pagsasangla ng isang third person ng kanyang property in favor of the debtor? Compensation stipulated. Baka meron silang usapan ng debtor at saka yung property owner na babayaran, etc. Or merong share, etc. Ganyan. Or pwede namang mabait lamang talaga yung pledgor or mortgagor. They are trying to help out the debtor by subjecting yung property nila to an encumbrance para nga naman masecure yung utang ng debtor na ito. Malamang-lamang, tiwala sila na makakabayad itong debtor, kaya willing sila na isangla yung kanilang sariling property. So, take note also that obviously if the principal contract is void, the pledge and mortgage is also void because of the principal, accessory follows principal. So, kung ang principal mo is void, accessory is also void. Take note also of the essential requirements of a pledge and also of a mortgage. So, number 1, it is constituted to secure the fulfillment of a principal obligation. So, dahil siya ay mga accessory, they cannot exist without a valid obligation. So, remember, yun nga sinabi ko sa inyo kanina, di ba? Accessory sila. They must depend on a principal contract, which in our case here, in a contract of pledge and a mortgage, is a contract of loan. Doon nakadepende ang pledge or mortgage. Kung walang contract of loan, hindi mag-exist yung pledge and mortgage independently. Siyempre, saan ka ba naman nakakita na nagsangla ka ng property mo tapos wala ka namang inutang? Parang sa pledge, nagpunta ka sa pawn shop. Yung pagsasangla sa pawn shop, yun ang pinakamagandang example ng pledge. So anyway, nagpunta ka sa pawn shop, sinangla mo yung alahas mo doon, tapos wala kang natanggap na pera na inutang mo. Sino ba naman ang masaya sa ganong klase ng usapan? So remember, hindi pwedeng pledge lang. There must be also a contract of loan. In addition to that, take note also that yung mga pledge can guarantee voidable, unenforceable, and even natural obligation. So, voidable, syempre valid yan until annulled. Yung unenforceable naman, pwede rin namang i-secure ng mga parties yan later on. Kasi alam niyo naman ang mga unenforceable contracts, they need to be ratified so that they will become enforceable. So, kung merong security, obviously, the security ay yung mga yung mga pledge and mortgage constituted, magiging enforceable din. Also, in case of natural obligations, pwede mo siyang i-secure. So, anyway, what else? Letter B pala, it is constituted by the absolute owner. So, yung magsasangla, the pledger or the mortgagor must be the owner. Kung hindi sila ang may-ari, remember, the pledge or the mortgage is void. Actually, pagka sinangla mo nga yung hindi mo pag-aari, there may be criminal liabilities as well. Tandaan nyo, which we will discuss later on sa latter part ng ating contract. Also, take note that future property cannot be mortgaged or pledged because there is a lack of ownership. So, ang tandaan nyo, yung pledger or mortgagor, they need to be the owner of the property. But remember also, on the other hand, the pledger or the mortgagor does not need to be the debtor or the borrower. Pwedeng ibang mangutang, pero sila ang magsasangla ng property nila. Ang nire-require lang ng law is sila ang may-ari ng property na isasangla nila. So here, remember, one who owns property can pledge or mortgage it to secure the debt of another. Anong tawag dyan? Accommodation pledge or mortgage. Yan. So, syempre, sa isang accommodation pledge or isang accommodation mortgage, mayroong accommodation pledger. So, siya yung nagsangla. Siya yung third person na binayaran or mabait na nagsangla ng property niya para sa kapakanan ng debtor. So, yun namang debtor here will now be known as your accommodated accommodated pledger. Yan. So, yun ang tawag sa kanya. Yung iba, ginagawa nilang kumpleto, accommodated debtors dash pledger or slash pledge, dash pala talaga, dash pledger. Tapos, yung pinagsasanglaan, syempre, ang tawag pa rin sa kanya ay pledgee. So, yung nagsangla, accommodation pledger, yung may utang na sa kapakanan niya, nangyari lahat ng mga bagay na to, is known as your accommodated. Siya kasing inaccommodate. Accommodated debtor dash pledger, and also, syempre, yung creditor who is also yung pledgee. So, yan ang mga parties mo. Same is true in case of a mortgage. What else? Number 3, the pledger or mortgagor has free disposal of the property or has legal authority. So, take note na yung act of pledging or mortgaging is an act of strict dominion or ownership. So, ang pwede lang gumawa niyan is yung tao na may-ari noong property. So, because it involves alienation or transmission of real rights in property, remember, pledger or mortgagor must also have the capacity or authority to dispose of the property. So, obviously, yung pledger mortgagor must have free disposal noong property na kanyang isasangla. So, anong ibig sabihin ng free disposal? The property is not subject to any claim by a third person. Now, also, take note na, ay qualify ko lang di ba, sabi ko kanina, yung pledger or mortgagor must be the owner of the thing. But remember also that they can act through an agent. So, ang agent, pwede siyang magsangla as long as it is within the authority given to them by the principal. So, remember, kailangan ang pledger or mortgagor has the capacity to dispose of the property, meaning sila yung may-ari. So, pwede nilang i-dispose. Kasi nga naman, isa nga namang element sa ownership is yung right to dispose of the property. Also, kung hindi naman sa kanila, like in the case of an agent, the agent must have the authority to make a disposition of the property. So, agent lang ang pumirma ng chattel mortgage or ng pledge or whatever contract it is. But remember here that the agent is authorized to do so. So, pledge or mortgage will involve the property of the principal. The agent is authorized or empowered to pledge or mortgage the same. Because here, kung yung agent ang pumasok sa contract and he is authorized, it is actually the principal who is pledging or mortgaging his own property, except that he acts through an agent. What else? The thing pledge or alienate or mortgage may be alienated pursuant to 2087. So, essence ng pledge and mortgage. So, because these contracts are constituted to secure the fulfillment of a principal obligation. So, itong condition na to, na kapag ka hindi makabayad or hindi ma-fulfill yung principal obligation, yung thing pledge or mortgage may be alienated. So, now this condition, even if not expressly stated in the contract, it is necessarily implied, because this is an inherent element of the transaction of mortgage or pledge. Talagang ganito. Ito talaga ang mangyayari if the principal obligation is not fulfilled. However, take note that the creditor does not automatically become the owner of the property if at the time stipulated, nag-expire na yung time of payment, nag-expire na yung time of fulfillment of the principal obligation, but the obligation still remains unpaid. Hindi matik na magiging owner na yung creditor. Actually, bawal nga yun. But ang gusto lang sabihin ng law dito is that the property, pledge, or mortgage may be sold. So, ibebenta yan in a foreclosure sale. So, it can be to anybody, which may include, syempre kung anybody, the term may also obviously includes the creditor. Tapos, from the sale, yung proceeds niya, yun ang ipambabayad doon sa utang. So, only remedy given to the mortgagee or pledgee is yun nga, to have the security given sold at public auction, proceeds of the sale applied to payment of the obligation secured by the pledge or mortgage. But take note here, bago magkaroon ng foreclosure sale, the pledgor and the mortgagor will remain the owner of the property kasi hindi pa naman na-foreclose. But remember, in 2112, there is an exception to this. Sa pledge, pwedeng magkaroon ng situation wherein the creditor can appropriate the thing pledged. Anyway, we will discuss that later on. Also, among the essential requirements is in case of pledge, the thing pledged must be placed in the possession of the creditor or a third person by common agreement. So, very simple. Kasi nga, ang isang pledge ay real contract. It is perfected only by the delivery of the thing pledge. So, kanino i-deliver yan? Either to the creditor or a third person by common agreement. Hindi kasi maper-perfect ang pledge. Essential element yan ng pledge kasi nga ito ay real contract. Meron siyang special essential element in addition to the three common elements. So anyway, what else? In case of mortgage, the document in which it appears must be recorded in the registry of property. So kailangan mayroong public instrument, real estate mortgage instrument, and also the instrument must be notarized and it must be recorded in the registry of property. So, obviously, yung registry of deeds or registry of property will not record your instrument if it is not notarized. What else? Creditor, remember, is not required to sue to enforce his credit. What does it mean? The creditor is not required to file an action to collect yung debt or credit that is due to him. So, yung creditor, hindi niya kailangan mag-file ng action for collection of sum of money. Hindi niya kailangan mag-file ng kung ano pang action na demanda para makolekta yung pera niya from the debtor. Remember, class, na sa isang pledge or mortgage, pwedeng idirekta na lang na i-foreclose yung mortgage property or ibenta yung pledged property in a public sale. To require that the creditor still files an action to collect first the debt before he can foreclose the mortgage or before he can sell in a public sale yung pledged property would defeat the purpose of the pledge or mortgage. Kasi nga, with respect to the property that is pledged or mortgage, merong preference yung creditor na yun. So, siya ang mauuna na masatisfy doon sa, yung claim niya ang mauunang masatisfy in case the property is sold in a public sale. So, di kailangan magdemanda para kolektahin yung amount ng utang. Pwede niyang idiretso na i-foreclose yung property or to subject it to a public sale. What else? Yung accommodation pledger or mortgagor, ano ba ang liability nila? So again, an accommodation pledger or mortgagor is a person who mortgages in his property to guarantee another person's debt. So they do not expressly assume personal liability for the debt. So sinangla ko lang yung property ko para i-secure yung debt ng debtor. But they do not assume personal liability para dun sa utang. Wala silang utang, tandaan nyo. So they cannot be compelled to pay the deficiency remaining after the mortgage has been foreclosed. And also, yung mga accommodation pledger or mortgagor will not be solidarily bound with the principal obligor. Imagine nyo na accommodation pledger mortgagor kayo. Wala kayong utang, pero sinangla nyo yung property ninyo para i-secure yung utang ng ibang tao. Tapos nung finorclose yung property nyo, may kulang, alangan namang habulin pa kayo, di ba, for the deficiency. Wala na nga kayong utang, nawalan pa kayo ng property. Alangan namang mag-abono pa kayo para sa utang ng ibang tao. So, remember, accommodation pledger, mortgagor, not liable for the deficiency after the property has been sold in a public sale. What else? Right of the creditor to sell the subject property where the debtor fails to comply with his obligation. So, ito ang right ng creditor kung nagkaroon ng failure to fulfill yung principal obligation. So, creditor is merely entitled to move for the sale of the thing pledged. Pwede lang niyang umpisahan yung mechanism para maibenta yung thing pledge sa isang public sale and also yung thing that is mortgage, pwede rin niyang i-start yung mechanism para maibenta siya sa isang foreclosure sale para makolekta niya yung claim niya doon sa proceeds noong public sale of the pledged or mortgage property. Yun lang ang right ng creditor. Hindi nakabayad, umpisahan mo na para maibenta na yung mga thing pledged or mortgage sa isang public sale at doon mo kunin yung claim mo doon sa pinagbentahan. So what else? Right of creditor to appropriate thing pledged or mortgage. So here again, this is not a right available to the creditor. Hindi automatic na kung hindi na fulfill yung principal obligation, yung creditor magiging siya na yung owner ng thing pledged or mortgage, which we have already discussed this one a while ago. So hindi automatic yun sa isang pledge or mortgage upon failure to pay the debt. So ano lang naman ang pwede dyan? Pwede lang kasing i-alienate yan. So, kailangan lang i-start ng creditor yung procedure so that the property pledged or mortgage may be sold at a public sale. But remember, class, that the creditor cannot appropriate or angkinin yung thing pledged or mortgage. Bakit? Because this is, remember, against public policy. So, kailangan i-foreclose niya yung bagay. So, there must be a public sale of the thing held as pledge or mortgage. Also, hindi pwedeng, hindi ka nakabayad, akin na lang. Bawal yon. So, hindi pwedeng, pagka hindi ka nakabayad, benta ko na lang sa iba. Hindi pwede. Kailangan, yung property should be sold at a public sale. Yun ang required ng law. Hindi siya nakabayad, akin na lang to. Akin na lang tong vacuum cleaner. Akin na lang tong washing machine. Hindi pwedeng ganon. Hindi rin pwedeng, hindi siya nakabayad. Benta ko na lang tong washing machine sa kapitbahay. Bawal din yun. Remember, class, kailangan dumaan muna sila sa isang public sale. That is what is required by law. What else? Any stipulation to the contrary is void, meaning even if it is stipulated in the contract, kapag ito ay di nabayaran ng principal utang, ang creditor na ang may-ari ng washing machine, bawal yun, tandaan ninyo. So even if it is stipulated in the contract of pledge, bawal pa din. What else? Also, take note yung term na pactum commissorium or pacto commissorio or pacto commissorio. I think that's yung spelling lang ang pinagkaiba. In other books, I see it as single M. In other books, double M siya. So, sinulat ko na lang lahat para sigurado tayo. But the most popular here is pactum commissorium. So anyway, pactum commissorium is the stipulation automatically appropriating the thing pledge or mortgage. Meaning that isa itong stipulation in the pledge or mortgage contract na ginagawang automatic owner ang creditor in the event of non-payment of the debt within the fixed term. So remember, ang pactum commissorium ay obviously, based on my discussions a while ago, it is a prohibited stipulation. So there is a prohibition against automatic appropriation of property or a prohibition against pactum commissorium. It is forbidden by law. It is declared null and void. But remember, kahit na null and void yung stipulation na yan, it does not render void the principal contract of pledge and mortgage, but only the stipulation itself. So, yung contract of pledge and mortgage is not invalidated, but only the stipulation itself. What else? The reason for the prohibition is usually yung loaned amount is mas maliit kaysa dun sa value ng thing pledge or mortgage. So, kaya ka nga nagsasangla, kaya ka nga nagpautang kung ikaw yung creditor, kaya ako pinautang tong amount na to kasi yung value ng kanyang security is more than the amount of the loan. Meron bang wala, ako hindi ako papayag ewan ko lang sa inyo kung gusto nyo magpakamartir. Imagine nyo, ang halaga ng utang is 1 million tapos ang nakasangla lang is isang motor. Saan kayo nakakita ng gano'n? Masesecure ba kayo? Do you feel security na bababayaran itong utang nyo or at least itong utang ng debtor, or at least kung hindi nabayaran yung utang ng debtor is maibebenta nyo yung property that secures the loan? Meron bang security na pakiramdam? Wala akong nararamdaman na security. So remember here, class, that is the reason. Usually kasi pagkatatanggap ka ng sangla, mas malaki ang value ng sangla. Even in pawn shops, yung appraisal ng alahas ninyo mas malaki kaysa dun sa amount na pwede nyong utangin. So, yun ang tandaan natin dyan. So, Forfeiture clause has traditionally been outlawed because it is contrary to Lamog PP. Tama naman. It's also contrary to law. So what else? Prohibition also applies to unimmovable, which is the object of a contract of Antichresis. Nakalagay ko sa book nyo, so sinama ko na rin lamang. So what else? Requisites or elements for pactum commissorium to exist. There should be a pledge, mortgage, or antichresis of the property by way of security for the payment of a principal obligation, and there is an automatic stipulation for automatic appropriation by the creditor of the property in the event of non-payment of the obligation within the stipulated period. Hindi ko na siguro kailangang explain. Very easy. Kayang-kaya nyo na yan. So anyway, remember again, pactum commissorium is a void stipulation. What else? How about if after hindi makabayad ng utang ng debtor, there is a subsequent voluntary cession or sale of the property. So voluntary rin naman yung debtor, feeling niya dahil hindi na niya mabayaran yung utang, voluntarily ibinenta na niya or inassign na niya yung property to the creditor. Obviously, this is allowed because there is a subsequent and voluntary act of making cession of the property mortgage in payment of the debt. So there is actually a novation here. Tapos nagkakaroon ng also pwedeng magkaroon din ng voluntary sale of the said property for the amount of the debt. So parang nagkakaroon ng dasyon and pago. So yun ang tandaan natin. Pwede naman kung syempre it is subsequent. Ang ayaw lang ng law is yung automatic appropriation ng creditor. So if subsequently after the default, the debtor chooses or decides to sell or to assign the property, cession nga, pwede naman yan later on. What else? Risk of loss of property, pledge, or mortgage. Very simple. Pledgee or mortgagee does not become owner. So remember here, ownership will remain with the debtor or the pledgor or mortgagor. Therefore, under the maxim res perit domino suo, the debtor owner bears the loss of the property. So principal obligation of pledge of loan pala, and also the principal obligation. Ayan, principal obligation of loan is not extinguished by the loss of the thing pledged or mortgage. So yun ang tandaan natin sa risk of loss. In 2089, we talk about pledge or mortgage being indivisible. So, pledge or mortgage is one and indivisible as to the contracting parties, and the rule will apply even if the obligation is joint and not solidary. Kahit joint yung obligation, remember, yung pledge or mortgage is still indivisible. Now, also, yung take note, indivisibility of the pledge or mortgage is not affected as well by the divisibility of the principal obligation. So the principal obligation may be divisible obligation. So it can be performed in parts, but remember, yung pledge or mortgage also will remain indivisible. Ano bang example ng divisible principal obligation? One that is capable of partial performance if the payment is by installments, ganyan. So the divisibility of the principal obligation will not be affected by the indivisibility of the pledge or mortgage. So what else? The consequences of indivisibility. So take note, if pledge is a single thing, so it is answerable for the whole obligation as soon as it falls due. So if there's an obligation, isa lang ang bagay na sinangla mo to secure the entire obligation. Remember, all portions of that property. So let us say isang lupa, yung lupa na sinangla mo is 100 square meters. Yung buong 100 square meters na yan will be answerable for the whole obligation as soon as it falls due. So what else? Number 2, if there are several things pledged or mortgaged, all of them are liable for the totality of the debt. The creditor will not be bothered to divide yung kanyang action by distributing the debt among the various things pledged. And also take note that even if only a portion remains, all of the things are liable for the balance. Debtor cannot ask for the release of one or some of the property, several properties pledged or mortgage, or any portion of any property, or the proportionate extinguishment of the pledge or mortgage until and unless the debt is paid in its entirety. So let us say for a 20,000 debt, nagsangla ako ng nag-pledge ako ng tatlong bagay, refrigerator, television set, and also vacuum cleaner. Gusto ko talaga yung vacuum cleaner. Hindi ko alam kung ba't lagi nalang vacuum cleaner. Naiisip ko. Anyway, so for 20,000 debt, tatlo yung sinangla ko. So remember here, class, that all of the properties which I pledge are liable for the debt. So they will secure the debt. So tandaan nyo dyan na yung tatlong yan, liable siya para sa buong 20,000 na utang. Now, what if I pay already 10,000? That is allowed. Partial payment is allowed. So I paid 10,000 pesos already, leaving a balance of 10,000. So again, if yung 10,000 remains unpaid, yung balance na yon, all of the things are liable for such balance. So yung aking, TV, refrigerator, and also vacuum cleaner may be sold at a public sale in order to pay for the balance of the debt. Now, if I pay 10,000, I cannot ask for the release of the pledge over the ref. Hindi pwede yun. Also, remember, I cannot ask for the release of a portion of the ref. So, hindi pwede. Release ng portion noong ting pledge. So, also take note that there will not be any proportionate extinguishment of the pledge and or mortgage hanggat hindi nababayaran yung buong utang. So, take note as well of the rules regarding debtor's heirs or creditor's heirs. So, debtor's heirs na nagbayad ng part of the debt, tapos yung debt na yan ng kanilang predecessor in interest is secured by a mortgage. So, kahit na binayaran na ng heir yung portion niya ng liability, remember, class, that hindi pwedeng mag-ask ng proportionate extinction of the pledge or mortgage. Anong example niyan? Debtor is indebted to creditor, let us say 1 million, tapos it is secured by a parcel of land na mayroong 200 square meters. So, para makatotohanan yung example. So, anyway, 1 million, tapos secured by a parcel of land worth with an area of 200 square meters. Tapos namatay si debtor, leaving 2 heirs. Now, heir number 1 pays for his proportion of the liability. So, nagbayad siya ng 500,000. But remember here, class, that this debtor, this heir number 1, cannot ask for the proportionate extinction of the mortgage. Hindi niya pwedeng sabihin na, pwede ba yung mortgage over yung 100 square meter portion be already extinguished? Kasi nakabayad na ako ng portion. Hindi. Because remember, indivisible ang ating pledge or end mortgage. What else? In case naman of the creditor, so creditor's heir who has received his share of the debt cannot return the pledge, object pledge, or cannot cancel the mortgage hanggat hindi pa nababayaran yung buong utang. So again, debtor may utang kay creditor. Ang utang ni debtor is 1 million secured by a mortgage over a parcel of land with an area of 200 square meters. Nung namatay si creditor, syempre may dalawa siyang tagapagmana. So tigkalahati sila, di ba? So anyway, itong si debtor pays heir number 1. Creditor's heir number 1. So, pays 500,000 pesos to heir number 1. Remember here that heir number 1 cannot cancel the entire mortgage kasi nga indivisible yan. So, kailan lang pwedeng i-cancel? Pagka si debtor, nabayaran na rin niya yung portion owing to heir number 2 before the entire mortgage will be extinguished or released. So yun ang tandaan natin dyan sa rules in case of heirs of debtors and creditors. What else? Exceptions to the rule of indivisibility. Each one of the several things guarantees a determinate portion of the credit. So bawat isang property, isang portion lang. So let us say here, take note, binabasa ko lang baka meron akong nakalimutan. Each one of them guarantees only a determinate portion of the debt. So example, ang utang ko sa inyo is 100,000 secured by a gold ring and also vacuum cleaner. So anyway, yung magandang vacuum cleaner to. So ang vacuum cleaner secures a 10,000 portion of the debt, and yun namang gold ring secures a 90,000 portion of the debt. So remember here, class, that each property secures a determinate portion of the credit. So yung 90 para sa gold ring, yung 10 para sa vacuum cleaner. Now, the debtor pays 10,000 to the creditor. So, remember here that if the debtor pays 10,000 to the creditor, he can demand the return of the vacuum cleaner. Bakit? Kasi yung vacuum cleaner na yan, guaranteed only a 10,000 portion of the debt. So, yun ang tandaan natin. So, here, partial extinguishment, divisible ang mortgage, ang pledge natin dyan. So what else? Where only a portion of the loan was released, the example in your book is on point. So the example in your book is that the debtor owes the creditor a certain amount. So let us say 1 million pesos yan. So this 1 million pesos is secured by a parcel, mortgage on a parcel of land with an area of 200 square meters. So anyway, yung creditor releases only a portion of 500,000. Hindi na release yung ibang portion noong loan. But same mortgage is constituted over yung 200 square meter parcel of land. So remember here, yung right of foreclosure in case the debtor fails to pay is only up to 50% of the parcel of land. Kasi yun nga namang loan na nirelease niya is only up to the amount of 50%. So here, exception to the rule of indivisibility. So what else? Foreclosure of mortgage constituted on several properties. So there is a mortgage on constituted on 2 or more properties. Again, this one is it is one and indivisible. It cannot be divided among the different properties. So yung mortgagee pwede niyang ibenta yung both properties, either or both properties. Pwedeng ibenta niya ng magkasama, pwede niyang ibenta ng magkahiwalay. So jointly or singly, di ko alam kung paano pronunciation yan, but sold to satisfy his claim. He may sell both or either of the properties. What else? Sell on a foreclosure sale. What else? All kinds of obligations can be secured by a pledge or mortgage as provided for in 2091. So any kind of obligation, whether it is pure or conditional, may be secured by a contract of pledge or mortgage. Kasi syempre nga naman, even voidable contracts can be secured. Unenforceable nga can be secured. Natural nga can be secured. Natural obligations are not even demandable in court. Remember, ang civil obligations lang ang demandable. But still, they can be used to secure such kinds of obligation. Ano pa kaya yung pure and conditional lamang? So, subject to a condition. Lalo naman yung pure. So, they may be secured by a contract of mortgage. So, also, guarantee, although hindi ko alam kung ba't sinama pa yan, kasama pala sa provision, may secure a conditional obligation. So, pledge agreement may stipulate that the pledge will also stand as security for any future advancement or renewals thereof. that the pledger may procure from the pledgee. So, merong property pledged, tapos merong utang that is secured by the property pledged. So, pwedeng magkaroon ng agreement that yung pledge already constituted may also secure future advancement. So, kung nagdagdag ng amount ng loan. So, the same security. So, meron din tayong ganyang concept sa mortgage. So, sa mortgage, ang tawag natin dyan ay dragnet clause, which we will study later on. So, what else? In 2092, this is a promise to constitute a pledge or mortgage. But remember, this will not create a real right. So, promise lang naman yan eh. If accepted, it will give rise only to a personal right, which is binding only on the parties, and it will create no real right over the property. So, what exists here is only a right of action to compel the fulfillment of the promise. Pero wala pa naman talagang pledge or mortgage. So, let us say, example, debtor borrows 10 million from creditor. The debtor promised to execute a mortgage to guarantee yung kanyang payment noong debt. The promise of the debtor to execute real estate mortgage was accepted by the creditor. So, suppose let us say the debtor has not yet constituted the mortgage. Pwede ba nating sabihin dito na meron ng mortgage contract? Siyempre, walang mortgage contract. So, there is no real right created, but what exists here is a personal right of the creditor to demand from the debtor the constitution of the mortgage. So, that is what you have to remember in 2091. 2092 pala. Please take note also of the criminal responsibility of pledger or mortgagor under 2092. In 2092, nagkakaroon daw ng criminal responsibility ang pledger or mortgagor if they offer in pledge or mortgage ang isang property as unencumbered, when in truth and in fact, it is subject to some burden. So, sabi nila, hindi ito nakasangla. Malinis ang titulo, walang sangla, pero later on, it will be discovered na itong property na ito is nakasangla sa iba. So, meron talaga siyang encumbrance, but the pledger or mortgagor will pledge it or mortgage it as an encumbered. So, yun ang unang way to be criminally responsible. Also, there is criminal responsibility if the pledger or mortgagor misrepresents himself to be the owner of the thing to be pledged or mortgaged, when in fact, hindi naman talaga sila ang may-ari. Sinangla nila yung cellphone ng kapitbahay nila. Imagine nyo, kapitbahay, cellphone ng kapitbahay niya, nananahimik, sinangla nyo. So, there is criminal responsibility for that. In addition to this, under 316 of the Revised Penal Code, remember, ang crime committed in case of real property is estafa. Kailan ito mangyayari? If, remember, it is committed by a person who, pretending to be the owner of any real property, shall convey, sell, or encumber, or mortgage the same. So, hindi siyang may-ari, pero anong ginawa niya? Binenta niya, in-encumber niya, or sinangla niya. Yan, encumber, mortgage is the same. Knowing that the real property is encumbered, shall dispose of the same as unencumbered. So, sinangla niya, tapos nung pagkasangla niya, sinabi niya wala itong encumbrance. Pero sa totoo lang, meron. Also, take note here that for estafa, it is essential that fraud or deceit be practiced upon the vendee at the time of sale. So, obviously, by analogy, this will apply to the case of a mortgagee. So, it is essential that fraud or deceit be practiced upon the mortgagee at the time of the mortgage. So, either you pretend to be the owner or you mortgage it mortgage it as unencumbered when in truth and in fact meron naman talaga siyang mga encumbrance. So yun ang 2092 in relation to 316. In 316, remember, of the revised penal code, it talks only about real property. So in 316, ang kanyang elements actually is the property is a real property. Number two, the offender must have pretended to be the owner. Otherwise, deceit or fraud would not be present. And number three, the fictitious owner must have executed some acts of ownership to the prejudice of the true owner. So anyway, these are the elements of estafa under paragraph 1 of Article 316. So anyway, that is it for chapter 1 of our lecture on pledge and mortgage. So this will be discussed on Wednesday for my Wednesday class, chapter 2 on Friday for my Thursday class, chapters 1 and 2 for Thursday. So anyway, thank you class and have a great day.